Hello, this is a presentation by Family First Legal, presented by yours truly, Beatrice Walker. Today's presentation will be on Maryland's annulment law. First, we will look at the qualifications for an annulment. First, you must have grounds, meaning the marriage must have been void. There is another category known as voidable, but that's not necessarily going to qualify you for an annulment. And we'll talk about that in just a moment. And then there's a residency requirement that the marriage was either performed in Maryland or that you were a resident of Maryland. And we'll, of course, talk again about that later. So moving into the void versus voidable argument. A void marriage will never be ratified, meaning there's no consent, there's nothing that can make a void marriage a real marriage. That marriage was void at the time that it was, at the time that the marriage was entered into. It was void under the law, and therefore it can never be made a valid marriage. And consent by the party who discovers that their marriage is void doesn't negate the fact that the marriage is still void. It can never be made a valid marriage. Whereas a voidable marriage, it may be deemed void by a court if the party who discovers that the marriage is voidable seeks to nullify the marriage within a reasonable period of time after discovering the issue of voidability. Now, ratification, consent will affect your ability to get a voidable or to make a voidable marriage void. Because if you consent to the voidable marriage, then that marriage is no longer voidable and it becomes a valid marriage. And ratification or consent to that can be assumed or presumed whenever a reasonable time passes after you've discovered that your marriage could be annulled and you've continued in the marriage. So then you may have, in fact, consented, and your consent now makes your marriage a valid marriage. And if it's a capacity issue as to why your marriage might be voidable, if you gain capacity and then you don't do anything like go into the court to ask the court to nullify the marriage, then your marriage will be deemed a valid marriage at that point. So voidable is very different from void. While you can make a voidable marriage void, it can also be made a valid marriage, where a void marriage will never be a valid marriage. In other words, a void marriage will always be grounds for annulment, and a voidable marriage may be grounds for annulment. And I'm using the word marriage loosely because if it's void, it was never really a marriage. So looking at the things that can happen to make a marriage void. A marriage is void at the time it was created or the time that it was engaged in or entered into if at the time of marriage there was a prior existing marriage. So if there was never a divorce decree granted for a prior marriage, meaning one party is already married to someone else, then that marriage is void. There is nothing that can happen that will make that void marriage become an actual valid marriage. Fraud or misrepresentation, which induced the marriage. If the party lied or misrepresented something that was really big, it can't be minor things like wealth. Wealth is still considered minor, even though some people might not consider it minor. It can't be wealth or minor things like, the things that you own. But it has to be something big that was fraud or misrepresentation, like saying that you can have children and you can't have children. That makes it void when you know that particular act is what induced the marriage. Now, if that didn't induce the marriage, meaning if that's not what caused the other party to marry you, then it's not fraud or misrepresentation that will allow you to void the marriage or allow the marriage to be void. Your marriage will only be void if the fraud or misrepresentation is the very thing that was used in order to lure the spouse into the marriage. And then there's mental incapacity or insanity. If the party is mentally incapacitated to the point they don't know what decisions they're making or what they're doing, then the marriage is void. You can't enter into a marriage while being insane or mentally incapacitated. Now, this is going to generally be those parties who are going to be long-term incapacitated or insane, insecure. The word is that it's incurable or continuous or ongoing. mental incapacity or insanity. So the marriage will always be void in those situations. And then marriage to family members within a certain degree of kin. So that's by statute. You would look at the statute to see what degree of kin the people are related. And if they're in first degree, generally that's going to be a void marriage. That is never going to be a valid marriage in Maryland. Voidable. These are the ones that we discussed that could be voided if once discovered within a reasonable time. The party who discovered it went to the court and asked the court to make the marriage void or to annul it. So that's minority or nonage. So if, say, a 15-year-old marries or someone marries a 15-year-old, not knowing how old the 15-year-old or the 15-year-old marries someone who's a lot older but doesn't realize they don't have the capacity or right to marry at that point, then that marriage is voidable. But at the point where that minor becomes an adult, if that minor continues in the marriage, that marriage is no longer voidable. It becomes something where it looks like they've consented or condoned or that they've agreed to the marriage. A party that is incapable of having intercourse. So if you married someone believing they were capable of having intercourse, now this is different from the void grounds. The void ground says that you married someone based on them telling you specifically that fact. And that fact alone is what induced you to marry them. So it's not. So if in fact the only reason you married someone is because you heard they were that they could have intercourse with you and you really wanted to have that and you wanted to have children and you heard that they could have that, the marriage would be void if that was what they used and that was the only thing that induced you to marry them. However, if that's not the case, if you discover that a party is incapable of having intercourse after getting married, you have a reasonable period of time after discovery to have the court declare your marriage void, or otherwise it becomes ratified or consented to. You've consented to the marriage and therefore the marriage is valid and no longer able to be made void. A marriage performed by one who is not legally able to perform such marriage ceremonies. So if you have someone, random person, perform your nuptials and you discover later that person was not ordained, nor was that person legally able to provide any type of binding marriage ceremony, and therefore your marriage could be voidable if after discovering that you immediately go to the court and ask the court to nullify it, or within a reasonable period of time ask the court to nullify it, then your marriage can be made void. However, if the period of time is beyond what the court would deem reasonable, then your marriage is now valid, and the only way out of that marriage would be through divorce. And then here are some others for voidability. That's fraud, force, duress, any of these things that are used to induce marriage. So I'll just give an example out of that, like force. Someone put a gun to your head and said, you're going to marry me. And they stand you in front of someone who officiates your wedding while you're sitting there at their shotgun wedding. Now, within a reasonable period of time after you went to the shotgun marriage, or you went to the shotgun wedding, so to speak, you go to the court and you say, I was forced to marry him, then the court will make your marriage void. However, if you continue in the marriage long after that shotgun is put away, you continue to act as a married couple and you continue in the marriage, then that then will make your marriage consented to, and therefore it's no longer voidable, or it cannot be made void. And then if a party is incapacitated at the time of marriage, it may be voidable. And that means they have the inability to consent. So we talked about capacity as being one of the prongs of a void marriage, but incapacity could be temporary, such as you're drunk on alcohol or high on narcotics at the time and you have no ability to really make decisions, but you get married. And in that instance, that marriage is voidable and it can be annulled because it's not a permanent condition that you're incapacitated or experiencing the temporary insanity or whatever. It's a temporary condition. Therefore, that means as soon as that condition's gone or lifted, you could make a decision to nullify your marriage. But if you do not make that decision, then at that point in time, you have now consented or ratified the marriage, and it's no longer voidable, or it can't be made void, so it becomes a valid marriage. Residency requirements. Generally, one party must reside in Maryland at the time of filing, and that party must have an intent to remain in Maryland, or the marriage that you're seeking to nullify or annul must have occurred in Maryland. And here are a few other considerations that you might want to consider with annulment. There is an evidentiary ground, and the grounds must be established by clear and satisfactory proof. And you must remember that Maryland courts are very reluctant to grant an annulment. So it really has to be very clear evidence that the marriage is void, or that you're coming to the court in a reasonable time after you discover that your marriage is voidable. So it has to be very, very clear. Without that, the courts are extremely reluctant to grant an annulment. And even with that, courts are reluctant to grant an annulment. So just keep that in mind. Property and alimony after an annulment. Depending on how long the parties have been married or have thought themselves to be married, the court will decide who owns what property, similar to an absolute divorce. However, this is not a divorce. This is an annulment, is as if the marriage never happened or if it never existed. However, there is an understanding that property might have accrued during that time between the parties, and therefore the court will split that property, similar to how marital and separate property are handled in an absolute divorce. Alimony can be allotted in an annulment, but generally that will be based on the circumstances. It will be very circumstantially related. So you'll want to give the court your circumstances, how you became dependent on that person, or how that person was the main breadwinner, and particularly if you were a stay-at-home parent, or the party, as part of that, what you believe was a marriage, you didn't work, didn't get an education, and that person has a higher earning wage level or a higher education level, then you will want to ask for alimony in this situation of annulment. Now, parenting plan and child support. Children born of an annulled marriage, even though the marriage is as if it never existed, and for all intents and purposes was never really a marriage, a child born to an annulled marriage will be a legitimate child. So it's not a question of illegitimacy because the marriage didn't exist. For the purposes of the child, the parents were married at the time of conception, at the time of birth. And so that child will be legitimate. So you will, in the case of an annulment, be able to decide custody, child support, who will have decision-making power, all of those things that you would decide in an absolute or limited divorce situation. As if you were married, you'll still be able to make those decisions where children are involved. So this is a general overview of annulment, and I hope you didn't get that it was an overly simple process to get an annulment. As I stated earlier, annulments can be very difficult to obtain in Maryland, so do consider that if you're thinking about getting annulment, you may want to consult with us. You can reach us by checking out our website, connecting with us on the Contact Us page at www.fflmd.com. Thank you.